Here we go. The People versus Edward LaRue. Anytime you hear the people in a case title, remember, it's not just the prosecutor versus the defendant. It's the entire state bringing charges. That's already a huge power imbalance.
Frozen screens, unmuted mics. Welcome to Digital Justice. A defendant's freedom now depends on whether he can click the right button. Tech glitches may seem funny, but here's the truth. Technology failures can literally stall your case. Should virtual court decide someone's freedom, or should justice stay strictly in person?
All right, and good afternoon, folks. Court does call the case of the People versus Edward LaRue.
Good morning, Your Honor. Marie Ursinski on behalf of the people requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Who's on the other side of this?
Mr. Valdisi.
Mr. LaRue, can you unmute yourself?
Classic Zoom court moment. Frozen screens, lag, and defendants who may or may not know how to unmute. You'd think after years of virtual hearings, this part would be smoother, but nope. Justice in the digital age means tech fails can literally stall your case.
Sir, and I'll just let you know your attorney.
The People versus Edward LaRue. Don't forget, when it's the people, it's the entire state against one man. High stakes, legal risks, and even Zoom chaos. LaRue shocks the court, firing his lawyer to go solo. Bold move or disaster waiting to happen. Let's dive into this courtroom showdown.
He stepped right out of the courtroom. So when he gets back in, can you let Hugh know we need it back? Mr. LaRue, can you unmute or no? Can he hear me? Or is that froze? I'm green.
I feel like nobody else turned their business on. Right?
Mr. LaRue, if you can hear me, can you wave your hand?
Big move here. Firing your court-appointed lawyer to go solo. Now,
LaRue wants to fire his lawyer and represent himself. Legally possible, practically reckless. Judges warn it's nearly impossible to face trained prosecutors alone. Would you risk your freedom on self-confidence? Or stick with a lawyer, even one you barely trust? This decision could change the entire course of trial.
legally, this is called pro-se representation. And yes, you have a right. But here's the kicker. Most judges will warn you. This is almost always a bad idea. Would you risk representing yourself in a criminal trial?
He's frozen.
I'm actually seeing him blink, but
Oh, you did? Okay. Thank you, Mr. Moon. Okay, now he's moving. All right, Mr. LBC, you're back in the courtroom. I'm sorry, this was your case. Well, before we go on, permission. She looks so different than in the little box. Okay. Permission to practice is great. Mr. LBC, your appearance.
Public Defender Coughlin, based on behalf of Edward LaRue, Your Honor.
Mr. LaRue, can you state your name, please, sir?
My name is Edward LaRue.
All right. This is date and time set for trial, correct? Pre-trial. All right.
Bond, battle time. Defense asks for a PR bond. Release with no cash, just a promise. Prosecutors argue danger, pointing to victim injuries. Judges balance compassion against community safety. Here's the question. Do you release him under monitoring, or keep him locked up? Which side of justice would you choose?
What are we doing?
At this time, I would be requesting adjournment. I do need to discuss some things with my clients.
All right.
Your Honor.
Pardon?
May I have a word with Your Honor?
Depends on what you want to say to me, Mr. LaRue.
If it's not about the case, then yes. I was going to fire my court-appointed attorney and represent myself in this matter and continue with the hearing as planned.
All right, Mr. LaRue, why do you want to do that?
I'm sorry?
Why do you want to do that?
It's been several weeks, and the court was adjourned last time just on the basis that I don't want to spend more time.
Translation: instead of sitting in jail, LaRue can walk free if he promises to show up for court. That's what a PR bond is. Personal recognizance. No cash up front, just his word. But judges often add strings, like GPS monitoring. Freedom with an ankle bracelet.
I'm in jail and I have some physical.
Just as freedom seems near, a new domestic violence report surfaces. Judges hate surprises like this. Bond isn't just about flight risk, it's about safety. LaRue insists he's the victim, not attacker. Should the court trust his word or protect the community first? Freedom or caution, which way should justice lean?
Physical health things going on that I wanted to deal with from the outside, some overdue medical procedures.
I was going to address bond.
Well, your attorney was going to address bond. You don't want him to do that? You want to try it for yourself, or what do you want to do?
Well, if he was going to address bond, I mean, I would like that. Yes, you're correct.
So I'm correct in what?
That I would like him to address bond. You're correct there.
Okay, so you want Mr. Babisi to continue representing you in this matter?
Yes, I thought.
Okay, great, thanks. I'm glad we got that cleared up. I'll adjourn the matter to July 3rd, 2000.
LaRue admits violating a no-contact order, then claims innocence, blaming the victim. Judges now face conflicting stories. In law, credibility is everything. Once trust breaks, it shadows every claim. Here's the engagement question. If someone violates court orders yet insists they're not guilty, would you believe them or doubt everything?
2023 at 1 p.m. And as about.
Yes, Your Honor. I believe with himself, because he came to appear. My client, he does have some health concerns, and he does have some family obligations to take care of. So we were hoping to switch his bond over to a PR bond. He has been in regular contact with me. He was actually in contact with me before the bench warrant was put out, but he had some technical difficulties. That's why he was unable to appear that day. So we would ask that the court change his bond to a PR bond.
Are you still on Oak, Mr. LaRue?
That is my permanent mailing address, yes.
Okay, thank you. Any response to the request for a bond reduction?
Yes, Your Honor. We would argue that bond should stay the same because the defendant hit the victim, bleeding from her nose and her face.
All right. Thing in here, though, is that initially, and I understand those things. However, on April 6th,
the judge doesn't decide. She waits for reports. LaRue's fate hangs on paperwork. No sweeping verdicts, just careful steps. For him, it's more time in jail. For us, it's proof justice often stalls on missing documents. Should judges risk release with uncertainty or play safe and delay? Your thoughts?
18th, the defendant was arraigned. He received a PR bond. He was out on bond and then just did not appear at the next proceeding.
Yes, he did not violate any terms of the bond.
Any terms or conditions. The conditions were continued. What I will do is I will reduce the defendant's bond to a personal recognizance, $25,000 bound. Defendant must be on a GPS prior to release.
And here's the plot twist. Just when it looks like LaRue's walking free, a new domestic violence report surfaces. Judges hate surprises like this because bond isn't just about flight risk, it's about protecting the community. One fresh allegation can slam the door shut.
Yeah.
Edward LaRue's case shows courtroom justice at its messiest: Zoom, chaos, self-representation risks, bond battles, and surprise allegations. The judge leaves him waiting, caught between freedom and jail. Was holding off fair or too harsh? Share your thoughts below and don't forget to like, comment, and subscribe for more breakdowns.
And are you working, Mr. LaRue?
No, I missed several interviews while I was in here, but
So that's a no? Thank
have
you.
high hopes of getting a job, assuming that's a no. Yeah.
Your Honor, I also have the community corrections report where he failed to report community corrections. And I have a Canton Police Department report where he did violate in Canton. And that was on April 24th of 2023.
April 24th
of 2023, and that was with the same victim. Yes, he admitted to being, he admitted to Canton Police, that he was at Amy's residence and with Amy for the night, and then he stated he left his residence but returned to get his phone after he had left for the night. So admits violating the no contact book too.
But did she, what was the reason he came into contact with the police? Did she call? I do see that report, but I don't see anything in that report as to why.
I know that they were dispatched.
Well, it apparently, I didn't see this. It says they were dispatched to that address for domestic violence.